Hi, Martin. How are you?
I'm well. How are you?
I'm very well, thank you. Yeah, you keeping
Good.
sane?
Just about. Just about. Yeah.
Excellent. Well, I've been keeping up with COVID-19 developments. You won't be
Have you now?
surprised to hear. I've seen our colleagues have been talking about various issues that arise for our landlord and tenant clients. I guess you've been watching that too.
Of course I have. Yes, I've seen that Jonathan Seatlow and Joanne have discussed frustration
Yeah.
and have decided that discharge of a lease by frustration or suggested that it's at least going to be very difficult in the current situation.
Yeah, exactly. And Ben and Jonathan and James were touching briefly on this concept of supervening illegality when they were talking about break clauses, and they didn't think that it really applied in that situation.
Yeah.
But that did get me thinking whether there are other situations where illegality, temporary illegality, might result in performance of particular obligations being either suspended or discharged, if not on the grounds of frustration.
Yes, I was thinking the same thing. I have to say that the law in this area seems quite confusing because there's a tendency to include impossibility arising from supervening illegality within the terminology of frustration.
Yes.
And if you look at chitty, for example, chitty on contracts, you'll see that supervening illegality is treated as a frustrating event.
Yeah.
And some of the cases, just to confuse matters further, refer to supervening impossibility when they're meaning supervening illegality.
Yes, I agree. And so supervening illegality, giving rise to impossibility of performance, is a thing in its own right, isn't it? It doesn't
Yeah, of course.
have to be a frustrating event. And you're looking at balancing, on the one hand, public policy in requiring people to comply with the law, and on the other hand, allocating the loss that arises because of the supervening event between the parties. So you've got this juggling exercise.
Yeah, so the starting point has got to be that there is no doctrine of partial frustration.
Yeah.
And certainly in the break clause context, as Jonathan Chu was pointing out, it's difficult to see impossibility of the performance of one of the conditions precedent as discharging the lease obligations altogether.
Yeah.
But can particular covenants, not options to determine the lease, be discharged by virtue of the coronavirus regs, or could they be suspended?
Yeah.
And if so, how do we decide which is which?
Yeah, so if you've got an obligation that you should be performing, it becomes illegal to perform it, but it's not sufficiently serious to result in discharge of the contract altogether, then what can you do?
Well, I think it certainly seems that in some of the very old cases, the courts have arguably been prepared to treat the lease obligations as discharged, such as positive obligations to use as a beer house in some of the old cases,
right? Yeah.
Which becomes illegal to perform as a result of changes in licensing laws. And the cases there talk of the non-performance being excused as being by act of law or involuntary on the part of the tenant.
Right, yeah. So, but in that example, is the tenant going to be completely discharged from this obligation to use it as a beer house? Can it use it for any purposes that it likes, or is this obligation just suspended for the duration of the illegality?
Well, I think in my beer house example, the obligation only to use as a beer house would certainly be suspended and would only revive if licensing laws changed.
Right, yeah.
In the meantime, during the suspension, the authorities suggest the premises probably can't be put to any use the tenant likes. And secondly, the right to use only as, say, a house rather than a beer house would only last as long as the illegality prevailed.
Right, okay. All right, well, let's think about something a bit different. So if you've got a building lease, for example, and so you've got land that's demised to the tenant, sometimes that's under quite a long lease. The tenant undertakes an obligation to erect buildings on that land. Let's say it's a shopping centre, for example. The landlord's taking rent for that. If, because of the current coronavirus regulations, the tenant who's in the middle of building out the premises is unable to complete that within the stipulated time, tenant can't claim that the contract's frustrated, as we've discussed, can't say it's not liable to pay the rent for that period. But what if the landlord wants to sue for damages for breach of that covenant? Could it do that? It probably could, but I think the tenant would have a defence, don't you think?
Yeah, I think the answer must be no. You'll recall the case of Cricklewood and Leighton from the 1940s, which supports the position that the coronavirus restrictions now would be a defence to that action, but all of the lease obligations remain enforceable.
Yeah, so defence to that action, but not a defence to a claim for rent under the lease. Yeah.
Exactly.
Yeah.
But what happens to the time for performance once the restriction is lifted? So take the example of a tenant who has 3 months under the contract to build, but was unable to build in practical terms for 2 of those months because of coronavirus restrictions.
Yeah.
Let's assume the restrictions are lifted after the 3rd month. Does the tenant only get a month to complete the works, or is he entitled to say that time starts to run again once the restrictions are lifted?
Yeah. Well, you can see the court might say, well, the obligation to perform within the stipulated time is suspended, but had the supervening event not occurred, you, the tenant, would only have had your 2 months to complete it. So why should you have a fresh 3-month period after the illegality has been lifted?
Yeah, but on the other hand, the tenant would argue that time shouldn't begin to run again until a reasonable period has passed from the lifting of the restrictions to enable him to assemble his team of builders and to rejig the contracts,
Right.
etc.
Yeah, I can see that. I can see the court would have some sympathy with that on a practical level. Yeah. There's also that John Lewis and Viscount Chelsea case, isn't there? A 999-year building lease, and the tenant was to demolish and rebuild the premises, and then the premises became listed in the meantime, and so the tenant was unable to fulfil its obligations, and the landlord brought proceedings for forfeiture, and the court said, well, actually, yes, there has been a breach prima facie here, but the tenant has a lawful excuse for its non-performance because of this supervening listing of the building. So
Yeah.
A defence to the action for forfeiture, but not a defence, again, to a claim for rent, for example.
Yeah, so in those types of cases, the lawful excuse doesn't discharge the relevant party from its obligations under the covenant. The covenant's not discharged, it subsists. And so in the John Lewis case, for example, where I think there were 930 years remaining on the lease, it could be anticipated that the obligation might revive during the course of the lease.
Yeah. But then you still got this issue about how long has the tenant got to complete its work after the supervening event has passed? That's not without difficulty.
No. And then what would happen if time had been made of the essence in the performance of the covenant? So that failure to perform in time is said effectively to deprive the other party of the benefit of what was intended he should obtain under the covenant. What happens then?
Yeah, well, you can see that might put a different complexion on things, mightn't it? Because if the parties have stipulated that time is to be of the essence and so to strictly observe the time limits in the contract, then does become more difficult to justify a defence to a forfeiture claim.
Yeah.
Although
coming back to the rationale of the doctrine, I think it exposes the clash between what's right and fair as between the parties and the public policy obligation in requiring observance of the law. Yeah,
it brings that into stark relief again, doesn't it?
Does.
So I think where we're at is that supervening illegality in this context is really something you can rely on as a defence to a claim. So it's a shield, but it's not a sword. So if you're a landlord, for example, under an agreement for lease, and you're up against a long stop date, and that passes during the period of supervening illegality, you'd have some difficulty bringing a claim for a declaration that the long stop date has moved beyond a particular date. But you ought to be able to use that as a defence to a claim by the tenant for damages, for example.
Yeah, that must be right. Yeah, absolutely.
So a shield, not a sword.
Indeed.
So, well, it's been very nice talking to you.
To you.
Shall we sign off and have a virtual beer?
Let's do that.
Okay.
Take care.
You too.